I have with me this morning Sean Casey. Sean is an attorney from Pittsburgh, Pennsylvania, and Sean's specialty is real estate closings as well as asset protection and estate planning. Sean and I are going to do a session this morning on land trust. Our objective is to teach you what you need to know on land trusts so that you can go home and use them in your career as a real estate entrepreneur. I want you to know what they are, why you're using them, and how to use them. And that's the subject of this section this morning. Okay, first one on the list is, what is a land trust?
Okay, a land trust is a specific type of trust. A trust is a legal instrument that you're going to create by using certain forms. Whatever you put in the form is what will cause the trust to be in existence. A land trust is a specific type of trust. It's set up to hold the title to real property. Set up so that the property will be titled in a trust, you'll have control over the trust, and you'll be able to make the trustee do what you want him to do.
Okay, so a land trust is really nothing more than a vehicle for holding title.
That's right.
Okay. How long has a land trust been around, Sean? Did you and I invent this?
No, we didn't. Much as I'd like to take credit, no, we didn't. It's been around a very long time, hundreds of years.
Hundreds of years. So we're just using what was already available to us for our protection and our benefit.
That's correct. So we're not making up new rules here. We're not telling you to go out and get yourself in trouble.
Okay. Well, what does a trust consist of? How many documents are involved in it?
Well, there's two parts. The first is you need a trust agreement between you as the beneficiary and the trustee.
Okay, let me get this straight now. The beneficiary is actually the owner of the trust.
That's correct.
Okay. The trustee is just the trustee for the trust appointed by the beneficiary to do nothing except what the beneficiary directs.
Right.
Okay, so if you want to own the property, you want to be the beneficiary.
That's correct.
And the truth is the trust owns the house.
That's right.
You own the trust, right?
That's right.
All right.
And the way that the trust owns the house is you have a deed that you're going to record. Unlike the trust agreement, you don't record the trust agreement ever.
Okay.
You do not need to do that, and we'll talk about privacy in a minute.
Okay.
But the deed, which is going to title the property into the trust, gets recorded.
So you record the deed at the courthouse if you're taking title to the property, you would record the deed from the seller to your trustee as trustee.
That's correct.
And take title to the property in the trust.
Right.
If you already own a property and you're putting it in a trust, you're the grantor and you're granting title to your trustee as trustee for your benefit.
That's correct.
Okay. So the deed will either go from the seller to your trustee or from you to the trustee.
That's right.
Okay. You record the deed at the courthouse, and at the same time you fill out the trust agreement.
That's right.
And you put it in your filing cabinet at home.
Correct.
All right?
Now, just one more point. You always have to have a trust agreement, folks. Do not deed properties to trustees and not have agreements with them. Otherwise, when they die, their spouses will say thank you for the house you donated, and you will end up in court.
So, as long as you're alive, the trust agreement is not as important. You can always produce one at a moment's notice because you're in control of it. But if you die while that property's in that trust and a trust agreement doesn't exist, you've created a mess for your heirs.
Yes.
Make sure you do the trust agreement. Take at least, 5 minutes to fill out a trust agreement?
At least 5 minutes.
Well, we're going to go through that and show them how to do that.
Exactly.
Well, let's talk about some of the benefits of putting a property in a land trust and why we'd want to do it, Sean.
Okay, the first and foremost benefit is to get some liability protection. Now, you're going to get this both personally and for your real estate. Because you see, right now what happens is this. If I sue you and I get a judgment, all of your real estate gets encumbered by the judgment. It automatically attaches. It becomes a lien on all of your real estate. If you own 10 houses with $1 million in equity, even if I've just got a $2,000 judgment, it's going to attach to all of your real estate. And that means if you want to sell any part of it, you want to mortgage any piece, you've got to pay me off to get me out of the way. So what's happened, he's been preaching it all weekend, is you let me get in control of your real estate and take your money. You do not want to be in that position, particularly if I'm coming after big dollars.
So that's the case if I own them in my own name.
That's right. And that's what most people will have is this situation now.
Yes. So the objective is to put the title to the property in a land trust so that a judgment against me personally does not attach to the property.
That's right.
Because I don't own the property. I own the trust, which owns the property.
Right. Okay. So what you're going to do is you're going to go home, you're going to take every piece of real estate you now own, put it into a separate land trust. You'll have a separate trust agreement, a separate deed that'll be recorded. You'll have each property in a separately created entitled trust agreement, or trust. And because of that, what will happen is this. If there's an accident at a property, let's say it's the 123 Main Street Land Trust, someone's going to look up, find out that's the owner, sue the owner. But they can't get a judgment against all the other properties because that property is owned by one trust, and the trust only owns one property.
In this case, the owner would be that trust.
That's right.
Go say that they'd be suing that trust, and they may get a judgment against that trust because it's the owner if the accident happened on the property. But they may also sue you personally because you were managing the property and you were involved in it, and so a judgment could come down against you personally as well.
That's right.
If it did come down against you personally, it would attach to you personally, but would have not attached to the rest of the properties because you don't own them. The trusts own them. But if they sue the trust that owns the particular property that had the accident or whatever, then it could attach to that property.
And that property
not affect
only.
The rest of your properties.
That's right.
Keeping all your eggs out of one basket is a smart move as well. Mm-hmm. So you have one trust, one house. Not more than one house in each trust. All right?
Yeah. And now, who's in control, Ron?
Okay. What about privacy?
Privacy is an important aspect of your real estate investment career. Two reasons. Number one is when it comes to lawsuits, if I can go down to the courthouse when someone comes to me and says, hey, I want to sue so-and-so, and I can find out that that person owns a lot of real estate, I'm a very happy guy. Because you see, it's easy to file a lawsuit and win. It's getting paid that counts. When I'm functioning on a contingent basis, I don't care about winning as much as I care about getting paid. If I come looking for you and you're in the courthouse, I know I got a winner, and I know I'm going to get paid. But if your property's all held in a land trust and I go into the courthouse, what do I find? Nothing. You're not there. And the point is, if you're not there, then I don't know whether or not I should take you down or try to. So I don't know what's there as far as filing a lawsuit.
Let's explain to them why they're not there. Okay? When you record the deed at the courthouse and you're the beneficiary, your name appears nowhere on the deed. The rest of the world don't have a clue you have any interest in this property whatsoever. Thus you have privacy. The only name that'll appear on the deed is the trustee's name, not the beneficiary's name. That's how privacy is created. And as Sean will attest, and I have learned from vast experience and from a lot of people throughout the country, you don't want to own anything as far as the rest of the world is concerned. You've got to keep your name off public record and out of the limelight. And privately go through life building an empire, but without the rest of the world knowing what empire you have. So using a land trust is a vehicle to generate that privacy.
That's correct.
Okay?
Second issue about privacy is this. When you're buying and selling a lot, everybody begins to know who you are. You're going to be dealing in certain neighborhoods an awful lot. And it's a real important point when it comes to being someone like, let's say, Disney Corporation. Can you imagine Disney going down to Orlando, knocking on a farmer's door saying, hi, we're from Disney, we're building a big theme park, we'd like to pay you 10 times what your land is really worth? No. How do they do it? They bought it in trust. Same reason you're going to be buying and selling in trust. Same reason Ron does. Realtors in Jacksonville won't even look at this guy. They think he steals houses. They think he carries a gun. Goes out and threatens a homeowner. Puts a gun to their head. He doesn't do that. He offers them a deal they can't resist.
Puts little old ladies out on the street.
That's right.
Yeah.
That's right. The fact they get money out of it has nothing to do with it. But you don't want your deals tempered or changed or adjusted by somebody else's perception or misperception of you. You want to be able to do business, buy them cheap, sell them for a lot of money. So you don't give the public a chance, or realtors or anybody else a chance to change how they would deal with you otherwise.
Okay. Next benefit is
it's easy to transfer a land trust.
Easy to transfer. Okay.
Two ways, of course. You could just do the old deed the property out of the trust when you sell it, same way you would sell now. But there's another way. Your interest in the trust is personal property. It's what's called a beneficial interest. You, as the beneficiary, own a beneficial interest, and as a result, that personal property can be transferred to another person. It can be assigned. The document you'll see in a little bit is called an assignment of beneficial interest. That assignment is simply a piece of paper that says you assign your interest to someone else. You sign it, the trustee signs it, they get it, and it's nowhere in a public record. It's a completely private transaction that you keep in your filing cabinet.
So if we had a property in the land trust, and I wanted to transfer my interest from me to you in the land trust, I simply fill out this one piece of paper and hand it to you, and you now own the land trust.
That's correct.
Since the trust already owns the property as a public record, nothing changes at the courthouse because we're not changing the title to the property. We're only changing the interest in the trust. And that doesn't require a public transfer, paying transfer tax or any other taxes, or any other closing costs for that matter. I hand him the piece of paper. He's the owner of the trust. Now, is this a taxable event, Sean?
Absolutely.
It is a taxable transfer. I must report this to IRS as if I would have deeded him the property. But as far as closing costs go, there aren't any. As far as the rest of the world concerned, there was no transfer. Which brings us to the next subject of due on sale clauses.
That's right. The Garden St. Germain Depository Institutions Act of 1982. Sound familiar to anyone? No? See, I knew they were going to say that. This is a federal law that says that the due on sale clause in your mortgage that you have on your house or houses is enforceable by the bank. It also says that there are certain exceptions to the due on sale clause. One of which, and the only one we care about, is this. You can transfer your real estate into trust for yourself without violating the due on sale clause. They cannot call the mortgage due because you transfer from yourself to a trust created for the benefit of yourself.
And this is federal law.
Federal law.
So this will work in Cleveland.
Even in Cleveland.
Okay?
Even in Cleveland.
So avoiding the due on sale clause is commonly taught because of you put the property in a land trust, and because of the ease of transfer, if I transfer it to you, basically I'm just hiding from the lender that I transferred it.
That's right.
When I transfer that beneficial interest, it does trigger the due on sale clause, does it not?
That's true.
Okay.
But they got to figure it out first.
So basically I'm just trying to hide it from the bank that I
Right.
transferred the beneficial interest.
Right.
Would you suggest we do that for transferring a trust to an owner-occupant?
No. They'd get confused and mess it all up.
Okay. So basically what we're saying here is if you want to use that to avoid the due on sale clause, that's okay as long as you're dealing with educated parties on both sides. Because if Sean and Pat, his new wife, were uneducated owner-occupants and I transferred a property to them via assignment of beneficial interest and they didn't have a clue what I did and they didn't understand due on sale clauses, as many of you don't, and they're going to communicate with the bank. They're going to tell the bank they own the property, and the bank could have the right to call the loan due. They do have the right. They could call the loan due, and it could create a problem for these unsuspecting homeowners. And I don't want to get anybody in that position. So therefore, I will not transfer a trust to a homeowner unless they are fully aware of what's going on, and that's rare, by the way, very rare. That I would even take the time to try to explain it to a homeowner, because if you try to explain this trust stuff to a homeowner, they're just going to know something kinky's going on here, and they're going to want to know how you trying to get at them next. It's been my experience not even mention this trust stuff to a homeowner. However, suppose Sean is an investor, an entrepreneur, understands, maybe a part of my association, understands trust. Now can I transfer this property to him for investment purposes, especially when I think he's going to wind up selling it and paying off the loan anyway? It'd be irrelevant. As long as he understands and I understand, I don't have a problem with it. So avoiding the due on sale clause is great, and it makes for a good seminar, but it also comes with a lot of problems if all the parties aren't educated involved in it. And it really comes down to this: it's nothing more than tricking the lender and letting them know, and trying to hide from them that you're transferring the property. That's all you're doing. You don't legally avoid the due on sale clause by using the land trust.
However, let me go through the steps real quick on how you do that.
All right.
A lot of times what will happen is this: you're running your ad in the paper. I buy houses fast, cash, close 10 days. Call me. Guy calls you up and says, I got a $50,000 house, $35,000 mortgage, I'm 4 months behind, I need $1,000, I want to go to Texas, I know there's a job there, my buddy said he can get me a job. All the guy really wants to do is move to Texas and save his credit. Very common scenario. If you haven't hit it yet, you're not listening.
Yes, it is.
People are going to be calling you with this scenario. You're going to say to him immediately, what kind of mortgage do you have? And the guy's going to say, one of them conventional things, and you'll say, is it FHA or VA? The guy will say no. What you're going to say to him next is going to make or break the deal. You will never mention the words, we're going to do a land trust, come down to my lawyer's office, I'm going to confuse you. Don't tell him this stuff. Tell him you'll make up his back payments, give him $1,000, make his mortgage payments, and eventually pay off his loan. The guy will yell hallelujah on the phone and come meet you anytime you want. And he comes into the office. Here's what you're going to do. He will immediately sign a land trust agreement, a deed into the trust. Now what's he done so far? Just what you've done. He's put the property into a trust. The next thing that will happen is he'll sign the assignment of beneficial interest. Now who's he going to transfer it to? You. Because you're going to want the interest. In exchange for that, you're going to pay him the $1,000, make up his $2,000 in back payments. You have now bought a property. Your name does not appear on the record. It's not on your credit report. Nobody knows you own it. You're making money. The bank has no idea what has happened.
And probably could care less. You're bringing their payments current, and you're going to keep them current. You've just done the bank a tremendous favor, haven't you?
Absolutely.
However, they don't look at it that way.
Well, no, they might be upset if they found out, but they rarely find out, notice, or care.
So what you're telling me is, by having the owner put the property in a land trust, and then you get an assignment of that land trust, you're still keeping it from the bank that you're transferring interest in the property.
That's
now,
right.
If the bank really got nasty and they wanted to call the loan due because they thought it was transferred, what would you do?
I'd tell them, that's okay, I'll keep the rent. No, I wouldn't do that.
Well, what could you do? Couldn't you just take the trust agreement down to the bank and say, look, I'm handling the property for this guy. Here's the trust agreement. He's the beneficial interest.
Because your seller has done what he's allowed to do.
Nothing to do about it. Just leave the assignment at home. Okay.
Next thing along the way.
Are you sure you want to go on video and tell them all these sneaky, underhanded tricks?
I don't know about that.
All right.
They might find out I'm a lawyer, Ron.
Personal loan liability.
See, one of the great things in life that you want to avoid is being personally liable on any loan that you don't have to borrow. As you know, Ron is a big advocate of not dealing with banks. But if you're going to deal with them,
at least
you're going to deal with them.
Not becoming personally liable anyway.
That's right. Which is hard to get money out of a bank without doing that.
That's true.
Let's face it.
That's
okay?
True.
But there are some instances, for instance, and I don't know how much you talked about assumptions yet this weekend, where you have assumable loans, non-qualifying. FHA and VA assumable loans. And what you folks have been doing generally is you go out there, the closing agent gets the assumption package, you put your name all over it, you take title, you sign the note to the bank saying you're going to be personally liable for it, and they slap it all over your credit report. From now on, you will not do that. You will take title in a land trust. The trustee will sign the documents with the bank as trustee. Does not make them personally liable. When the lender gets it back, they will put in their computer that the trust owns the property. It will not be on your credit report. You've not agreed to be liable. And nobody knows you bought it because the title was taken directly into the trust.
Okay, we better clarify that, because I can see a problem here coming. Sean said that the trustee will sign a document for the bank. Let's clear this. You are not going to walk into a bank and say, I want my trustee to sign the documents for me because I don't want to sign them. That's not what he means. He means if you're assuming a no qualifying loan, FHA or VA, or seller financing without the due on sale clause, and only if you're assuming that loan, then you can have the trustee sign as trustee. The trustee's not liable as trustee. You're not liable. You're not even on the documentation. But that will only work now with no qualifying loans. Make sure you understand that. If you've got a loan that you owe your bank right now, and you signed on it, personally guaranteed it, you're stuck with it till you pay it off or till you die. One of the two. It's the only way you're going to get out of it. Okay? But in the case of no qualifying loans, what we don't want you to do is go out and assume them in your name and let them go in your credit report when it's totally unnecessary. Because you see, without the due on sale clause in them, they can't stop the assumption. They don't control the assumption. That's why you want your trust to assume it, and it'll never come back on you personally. Incidentally, a tip on that while we're on that subject. Do not under any circumstances give your trustee Social Security number up when you're doing that. There's a place on the assumption package for you to put your trustee Social Security number. Do not, in fact, don't even get possession of your trustee Social Security number, and then you can't inadvertently give it away. Because then, when the property's sold, the tax reporting will go to IRS and with the trustee Social Security number, and they don't have any interest in the property. You're doing them an injustice. So the beneficiary Social Security number is the one that you will use if one is called for on that assumption package. However, I have a habit of putting "to be applied for" in that spot. By the way, does an ID number required for a trust?
No.
No? No federal ID numbers needed?
No federal ID number, no separate tax reporting. We'll get to that.
Okay. So do you see how that avoids loan liability when you're assuming a no qualifying loan? What about when you're giving an owner-back, seller carryback financing? Same thing. Trust buys house. Trustee signs the mortgage as trustee. As long as the words "as trustee" are after the trustee's name, you not have personal liability on that note mortgage unless he does something illegal, unless he commits fraud, or something of that nature. For non-payment, the trustee is not going to be held liable. You as the beneficiary are not even on the note mortgage. In fact, you're not even in the paperwork anywhere except on your own trust agreement. The beneficiary signs nothing when you're buying. Nothing. You don't even exist as far as the seller is concerned. So let the trustee assume it as trustee. Therefore, you're not liable. They're not liable. What's liable? The property is liable for the note mortgage. So we've avoided loan liability except in those cases where we have to go into our bank and borrow money and personally guarantee them.
That's correct.
Okay?
Another benefit of the land trust is that anybody can own it. Now, how you own your interest in your land trust is you lift yourself as the beneficiary on the schedule. You can own it. You and your wife, you and a partner, a partnership, a limited liability company, a limited partnership, a corporation. Any entity can own the land trust, including your living trust. Which brings us to another point, which is this is the beginning of an estate plan for you. First thing you did is protect your assets. The next step that you need to look at down the road is using a living trust to avoid probate and keep control of your assets so they go where you intend after you die. But that's another seminar.
Well, let's go ahead and expand on that while we're on it.
Okay.
Is it a good idea to title your properties to a living trust as most estate planning attorneys will advise?
No.
Why?
And the reason for that is this. In your living trust, you're going to put basically everything of value that you own. You don't want to put everything you own in one spot and then put it all, your real estate, titled into the living trust, because it exposes all your assets to liability, which is what we're trying to avoid. You never take title in your living trust to real estate.
Because the living trust will be the deed holder as of public record.
That's right.
As the owner of the property.
That's right.
So, in other words, if something happened on that property, smoke alarm doesn't go off and kids get burned up in a fire, there's no question that the owner of the property will get sued.
That's right.
And the owner of the property happens to be your living trust, which contains everything you own.
That's right.
So in other words, you're saying everything you own would then be at risk.
That's right.
Doesn't sound too smart to me, does it to you?
No.
Okay.
Not at all. So what you're going to do is this. You're going to own your properties in the land trust, and your land trust will be owned by your living trust. The living trust will be the beneficiary of the land trust. So now you've got what you want, which is your real estate inside of and controlled by your living trust, but you don't expose it to liability.
Well, what did that accomplish?
That keeps me from getting sued in my living trust.
Okay. Now, let's take that same scenario. The land trust now owns the house, not the living trust. The land trust owns the house. The fire happens. What gets sued? The land trust, because it owns the house. What's at risk? What's in the land trust? One house.
Right.
So instead of having all your other assets at risk, because the land trust is the deed holder of public record, it's the only thing that's at risk, is whatever's in that trust is that one property. So it doesn't even affect your living trust that way. In fact, the living trust will never even come into it. No one will even know it exists, except you and the other parties in it. Since it's not on public record, it's not subject to attack. You never want a living trust to be on title as the owner of a property.
That's correct.
And if it is now, if you have a living trust now that own houses, simply a matter of having the living trust deed it to the land trust, and then have the land trust beneficial interest attached to your asset page of your living trust.